The sitting is open. The Court meets today pursuant to Article 58 of its statute and Article 94 of its rules to read out in open court its judgment in the case concerning application of the International Convention for the Suppression of the Financing of Terrorism and of the International Convention on the Elimination of All Forms of Racial Discrimination, Ukraine versus Russian Federation. I recall that the proceedings in the present case were instituted on 16 January 2017 by Ukraine against the Russian Federation with regard to alleged violations by the latter of its obligations under the International Convention for the Suppression of the Financing of Terrorism of 9 December 1999, to which I shall refer as the ICSFT, and the International Convention on the Elimination of All Forms of Racial Discrimination of 21 December 1965, to which I shall refer as CERD. In accordance with the usual practice, I shall not read out the introductory paragraphs of the judgment, which set out the main elements of the procedural history of the case. I shall also omit some paragraphs and summarize others. I shall therefore begin reading the judgment at paragraph 28. The full text of the judgment will, of course, be available at the close of the sitting. The present proceedings were instituted by Ukraine following events which occurred from early 2014 in eastern Ukraine and in the Crimean Peninsula. The situation in Ukraine is very different today than what it was when Ukraine submitted its application in January 2017. The parties are presently engaged in an intense armed conflict that has led to a tremendous loss of life and great human suffering. Nevertheless, with regard to the situation in eastern Ukraine and in the Crimean Peninsula, the case before the Court is limited in scope and is brought only under the provisions of the ICSFT and CERD. The Court is not called upon to rule in this case on any other issue in dispute between the parties. With regard to the ICSFT, the applicant instituted proceedings relating to the events in eastern Ukraine, alleging that the Russian Federation failed to take measures to prevent and suppress the commission of offenses of terrorism financing. In particular, the applicant refers to acts and armed activities in eastern Ukraine allegedly perpetrated by armed groups linked to two entities that refer to themselves as the Donetsk People's Republic, or DPR, and the Luhansk People's Republic, or LPR. Other acts to which the applicant refers were allegedly perpetrated by armed groups and individuals in other parts of Ukraine. With regard to CERD, the applicant refers to events which took place in Crimea from early 2014, after the Russian Federation took control over the territory of the Crimean Peninsula, alleging that the Russian Federation has engaged in a campaign of racial discrimination, depriving Crimean Tatars and ethnic Ukrainians in Crimea of their political, civil, economic, social, and cultural rights in violation of its obligations under CERD. The Court recalls that in its judgment of 8 November 2019 on preliminary objections, it considered that the dispute consists of two aspects. The first relates to the ICSFT, and the second relates to CERD. The Court further stated that in the present proceedings, Ukraine is not requesting that it rule on issues concerning the Russian Federation's alleged aggression or its alleged unlawful occupation of Ukrainian territory, nor is the applicant seeking a pronouncement of the Court on the status of the Crimean Peninsula under international law. These matters do not constitute the subject matter of the dispute before the Court. In the same judgment, the Court found that it had jurisdiction on the basis of Article 24, Paragraph 1 of the ICSFT and Article 22 of CERD to entertain the claims made by Ukraine under these conventions. Thus, the jurisdiction of the Court is limited to the alleged violations by the Russian Federation of its obligations under the two instruments invoked by Ukraine, and does not concern the conformity of conduct of the Russian Federation with its obligations under any other rules of international law. Before addressing Ukraine's specific claims under the ICSFT, the Court considers the Russian Federation's objection based on the clean hands doctrine, which in the Court's view was invoked as a defense on the merits. The Court considers that the clean hands doctrine cannot be applied in an interstate dispute where the Court's jurisdiction is established and the application is admissible. Accordingly, the invocation of the clean hands doctrine as a defense on the merits by the Russian Federation must be rejected. The Court then turns to the interpretation of certain provisions of the ICSFT, starting with the meaning of the term funds. Under Article 2, Paragraph 1 of the ICSFT, the provision or collection of funds is a constituent element of the offense of terrorism financing, the actus reus. The term funds is defined in Article 1, Paragraph 1 as meaning, I quote, assets of every kind, whether tangible or intangible, movable or immovable, however acquired, and legal documents or instruments in any form. End of quote. The terms funds and assets of every kind in the ICSFT are to be interpreted in accordance with the rules of treaty interpretation stipulated in Articles 31 to 33 of the 1969 Vienna Convention on the Law of Treaties. The Court first turns to the text of Article 1, Paragraph 1 of the ICSFT. The definition of funds in that paragraph begins with a broad reference to, I quote, assets of every kind, whether tangible or intangible, movable or immovable, however acquired. End of quote. The rest of the paragraph provides a non-exhaustive list of documents or instruments that may evidence title to or interest in such assets. While the phrase assets of every kind is an expansive one, the documents or instruments listed in the definition are ordinarily used for the purpose of evidencing title or interest only with regard to certain types of assets, such as currency, bank accounts, shares, or bonds. The Court notes that the use of the phrase "but not limited to" in Article 1, Paragraph 1 suggests that the term funds covers more than traditional financial assets. The term also extends to a broad range of assets that are exchangeable for or used for their monetary value. The Court then takes into account the context in which the term funds is used in other provisions of the ICSFT, which suggests that the term funds is confined to resources that possess a financial or monetary character. The Court then takes into account the object and purpose of the ICSFT. It notes that the preamble and the title of that convention suggest that the object of the ICSFT is not to suppress and prevent support for terrorism in general, but rather to prevent and suppress a specific form of support, namely its financing. Travaux préparatoires confirm the aforementioned interpretation of the term funds. In light of the foregoing, the Court concludes that the term funds, as defined in Article 1 of the ICSFT and as used in Article 2 thereof, refers to resources provided or collected for their monetary and financial value, and does not include the means used to commit acts of terrorism. Consequently, the alleged supply of weapons to various armed groups operating in Ukraine and the alleged organization of training for members of those groups fall outside the material scope of the ICSFT. In the present case, therefore, only monetary or financial resources provided or collected for use in carrying out acts of terrorism may provide the basis for the offense of terrorism financing, assuming that the other elements of the offense referred to in Article 2, Paragraph 1 are also present. Next, the Court turns to the interpretation of Article 2, Paragraph 1 of the ICSFT in order to determine the scope of the terrorism financing offense defined therein. The Court begins by recalling its previous finding in the 2019 judgment on preliminary objections that while the financing of terrorism by a state as such is not covered by the ICSFT, that convention does require states to act to suppress and prevent the commission of the offense of terrorism financing by all persons, including by state officials. The Court then considers the scope ratio materiae of the offense of terrorism financing. Multiple provisions of the ICSFT refer to the commission of offenses set forth in Article 2, including Articles 4, 8, 9, 12, and 18. The Court takes note that Article 2 sets out two kinds of offenses. First, the offense of terrorism financing, which is addressed in the chapeau of Article 2, Paragraph 1, and second, the two categories of underlying offenses or acts, which are stipulated in Article 2, Paragraph 1A and B, and to which the Court refers as predicate acts. In the view of the Court, the phrase offenses set forth in Article 2 should be understood to refer only to the offense of terrorism financing, while the predicate acts themselves are not offenses falling within the scope of the ICSFT. The Court next addresses the two mental elements of the offense of terrorism financing set out in Article 2. According to that provision, the commission of the offense of terrorism financing requires that the funds in question be provided or collected either with the intention that they should be used or in the knowledge that they are to be used in order to carry out the predicate acts. In support of its claims, Ukraine relies entirely on the mental element of knowledge. Accordingly, the Court confines its analysis to the interpretation of the phrase, in the knowledge that they are to be used. A determination of whether the element of knowledge is present must be made on the basis of objective, factual circumstances. The element of knowledge may be established if there is proof that the funder knew that the funds were to be used for the commission of a predicate act. In this regard, it may be relevant to look at the past acts of the group receiving the funds in order to establish whether that group is notorious for carrying out predicate acts. On the other hand, the characterization by a single state of an organization or a group as terrorist is insufficient on its own to displace the need for proof of the funder's knowledge that the funds in question are to be used to carry out a predicate act. The Court then addresses the scope and interpretation of the predicate acts defined in Article 2, Paragraph 1A or B. Having already established that these predicate acts are not themselves offenses under the ICSFT, the Court only interprets the scope of Article 2, Paragraph 1A and B to the extent necessary to inform its conclusions regarding the alleged violations by the Russian Federation of its obligations with respect to cooperation in the prevention and suppression of the offense of terrorism financing. The category of predicate acts specified in Article 2, Paragraph 1A, is defined by reference to the treaties listed in the annex to the ICSFT. With respect to the category of predicate acts specified in Article 2, Paragraph 1B, the Court notes that it is not enough for deliberate killings or serious bodily harm to civilians to have occurred. It is also essential to demonstrate that, I quote, the purpose of such act, by its nature or context, is to intimidate a population or to compel a government or an international organization to do or to abstain from doing any act. End of quote. The Court next recalls that the question before it is whether the respondent has violated its obligations under the ICSFT to take measures for and to cooperate in the prevention and suppression of terrorism financing, including by acting to freeze the accounts of suspected terrorism financiers, assisting in the investigation of such offenses, initiating prosecutions, or otherwise taking practicable measures to prevent the financing of terrorism. Answering this question requires the Court to interpret and apply obligations under Articles 8, 9, 10, 12, or 18 of the ICSFT. In so doing, it will be guided by its interpretation of Articles 1 and 2 of that Convention, in particular the term funds. Consequently, it is not necessary for the Court to evaluate predicate acts, the commission of which is sustained solely by the supply of weapons or other means used to commit such acts. The Court further recalls that the offense of terrorism financing is distinct from the commission of predicate acts. In order to decide on the alleged violation of the obligations invoked by Ukraine, it is not necessary for the Court to first determine whether the specific acts alleged by Ukraine constitute predicate acts. Finally, the Court notes that it does not have sufficient evidence before it to characterize any of the armed groups implicated by Ukraine in the commission of the alleged predicate acts as groups notorious for committing such acts. Accordingly, to establish the element of knowledge, it must be shown that at the time the funds were allegedly collected or provided to the groups, the alleged funder knew that the funds were to be used to carry out predicate acts. The Court next addresses certain questions of proof. It states that in deciding Ukraine's claims under the ICSFT, it will determine whether the evidence adduced by Ukraine is convincing. The Court also notes that each provision of the ICSFT invoked by the applicant imposes a distinct obligation upon states parties to that convention. In each case, the Court must first ascertain the threshold of evidence of terrorism financing that must be met for an obligation under that provision of the ICSFT to arise. If the Court finds that for a given provision of the ICSFT, the relevant obligation did arise for the Russian Federation, it must then determine whether the Russian Federation has violated that obligation. The Court then turns to the examination of the alleged violations by the Russian Federation of its obligations under the ICSFT, starting with Article 8 thereof. Article 8 of the ICSFT imposes upon states parties various obligations, inter alia, to identify, detect, freeze, or seize funds used or allocated for the purpose of committing the offenses set forth in Article 2 of the ICSFT. The applicable evidentiary threshold under Article 8 of the ICSFT may differ depending on the scope and nature of the precise obligation at issue. For instance, the obligation to identify and detect funds allocated for the purpose of terrorism financing entails a lower threshold than the obligation to freeze such funds. Since the applicant is primarily concerned with the alleged non-compliance by the Russian Federation with its obligation to freeze certain funds, it is necessary to ascertain the evidentiary threshold required for a state party to the ICSFT to be required to freeze funds alleged to be used or allocated for terrorism financing. The Court is of the view that the obligation under Article 8 to freeze funds only comes into operation when the relevant state party has reasonable grounds to suspect that those funds are to be used for the purpose of terrorism financing. The Court notes that this standard is in line with that adopted by the Financial Action Task Force in its special recommendations on terrorist financing. The Court also notes that the obligations under Article 8 are not contingent on a state party receiving information from another state party. In the present case, however, Ukraine's arguments primarily relate to the communications it submitted to the Russian Federation regarding the alleged use of certain funds and accounts for the purpose of committing offenses under Article 2. The Court therefore focuses its analysis on these communications. The Court states that of the note verbale and requests for legal assistance submitted to it by Ukraine, only 4 contain descriptions of specific persons and accounts alleged to have been associated with the financing of predicate acts under the ICSFT. The Court concludes that these note verbale do not contain sufficiently specific and detailed evidence to give the Russian Federation reasonable grounds to suspect that the accounts, bank cards, and other financial instruments listed therein were used or allocated for the purpose of committing the offenses under Article 2 of the ICSFT. The Russian Federation was thus not required to freeze those funds. In light of the foregoing, the Court concludes that it has not been established that the Russian Federation has violated its obligations under Article 8, Paragraph 1 of the ICSFT. The Court next considers Article 9 of the ICSFT, which concerns the obligation of a state party to investigate allegations of the commission of terrorism financing offenses by alleged offenders present in its territory. The Court notes that the threshold set by this provision is relatively low. For the obligation to investigate to arise, Article 9, Paragraph 1 requires only that a state party receive information that a person who has committed or who is alleged to have committed the offense of terrorism financing may be present in its territory. In circumstances where the information only alleges the commission of an offense under Article 2, it is not necessary that the commission of the offense be established. Indeed, it is precisely the purpose of an investigation to uncover the facts necessary to determine whether a criminal offense has been committed. Moreover, credible information received from any other source may give rise to the obligation to investigate. At the same time, however, the Court considers that Article 9 does not require the initiation of an investigation into unsubstantiated allegations of terrorism financing. If a state party has received sufficient information of alleged terrorism financing committed by an individual present on its territory, it is required to undertake a meaningful investigation into the alleged facts in accordance with the laws and procedures it would ordinarily follow when presented with information on the commission of a serious crime. Furthermore, in fulfilling its obligation to investigate, a state party must also endeavor to cooperate with any other interested states parties and must promptly inform them of the results of its investigation. The Court next considers whether the Russian Federation received sufficient information to require it to investigate any alleged offenses under Article 2 of the ICSFT. Ukraine has pointed to several note verbale sent from its foreign ministry to the foreign ministry of the Russian Federation, which, it argues, contained credible allegations of terrorism financing by individuals in the territory of the respondent. In the view of the Court, while some of the note verbale contain alleged facts that fall outside the scope of Article 2 of the ICSFT, three of the documents adduced, in particular the note verbale dated 12 August 2014 and 29 August 2014, contain sufficiently detailed allegations to give rise to an obligation by the Russian Federation to undertake investigations into the facts alleged therein. The information received included a summary of the types of conduct allegedly undertaken by members of armed groups associated with the DPR and LPR that Ukraine considered to constitute predicate acts under the ICSFT, the names of several individuals suspected of terrorism financing, and details regarding the accounts used and the types of items purchased with the funds transferred. The Court considers that such information met the relatively low threshold set by Article 9 and thus required investigation by the respondent. In light of that conclusion, the Court proceeds to determine whether the Russian Federation met its obligation to undertake a meaningful investigation into the facts alleged in the note verbale. The Ministry of Foreign Affairs of the Russian Federation first responded to the Ukrainian communications in a note verbale dated 14 October 2014. In that communication, the ministry informed Ukraine about, I quote, the need to provide the Russian side with factual data on the issues brought up, end of quote, in the Ukrainian communication. However, the Russian Federation provided no clarification as to the precise additional information that was required. Subsequently, on 31 July 2015, the Ministry of Foreign Affairs of the Russian Federation sent Ukraine a note verbale that included further details on the actions taken by the competent Russian authorities. These included the results of investigations into two of the alleged offenders. However, no clear information was provided by the respondent concerning the other alleged offenders described in the Ukrainian communications as being present in the Russian territory. The Court takes note of the amount of time that elapsed before the Russian Federation provided the aforementioned responses to the Ukrainian note verbale. In this regard, the Court observes that a 2019 report issued by the Financial Action Task Force stated that the Russian Federation generally answers requests for mutual legal assistance within 1 to 2 months. It is therefore notable that, almost 1 year after receiving the Ukrainian allegations, the Russian Federation appeared to have failed even to identify several of the alleged offenders. Furthermore, to the extent the respondent encountered difficulties ascertaining the location or identity of some of the individuals named in the Ukrainian communications, it was required to seek to cooperate with Ukraine to undertake the necessary investigations and specify to Ukraine what further information may have been required. In light of the foregoing, the Court concludes that the Russian Federation has violated its obligations under Article 9, Paragraph 1 of the ICSFT. Turning to Article 10, Paragraph 1, the Court recalls that it requires states parties to the ICSFT to either prosecute or extradite alleged offenders of terrorism financing offenses under Article 2. The Court observes that the applicant's arguments appear to be limited to an alleged violation by the Russian Federation of its obligation to prosecute. The obligations found in Article 10, Paragraph 1 of the ICSFT are ordinarily implemented after the relevant state party has performed other obligations under the ICSFT, such as the obligation under Article 9 to conduct an investigation into the facts of alleged terrorism financing. In addition, Article 10 does not impose an absolute obligation to prosecute. The competent authorities of the states parties to the ICSFT retain the responsibility to determine whether prosecution is warranted based on the available evidence and applicable legal rules, so long as such decision is taken in the same manner as in the case of other grave offenses under the law of that state. The Court notes that the decision to submit a case to the competent authorities for purposes of prosecution is a serious one that requires, at a minimum, reasonable grounds to suspect that an offense has been committed. The Court recalls its finding that the information provided by Ukraine to the Russian Federation did not give rise to reasonable grounds to suspect that terrorism financing offenses within the meaning of Article 2 of the ICSFT had been committed. In light of that finding, the Court does not consider that the Russian Federation was obligated to submit any specific cases to the competent authorities for the purposes of prosecution. Based on the foregoing, the Court concludes that it has not been established that the Russian Federation has violated its obligations under Article 10, Paragraph 1 of the ICSFT. The Court then considers alleged violations of obligations under Article 12, which requires state parties to the ICSFT to assist other states' parties in their investigations into terrorism financing. In this regard, the Court recognizes that states possess significant discretion in implementing the ICSFT in their domestic law. All that is necessary for an investigation to fall within the scope of Article 12 is that the subject matter of the investigation pertain to the offenses covered by Article 2 of the ICSFT. The ICSFT itself need not be specifically mentioned in a request for legal assistance for the obligation under Article 12 to come into operation. Of the 12 requests for legal assistance that have been submitted by Ukraine to the Court, only 3 involved investigations into the provision of funds to persons or organizations alleged to have engaged in the commission of predicate acts. These requests concern allegations that citizens of the Russian Federation were involved in fundraising for the DPR or LPR. The Court therefore limits its analysis to whether the respondent fulfilled its obligations under Article 12 with respect to the 3 requests for legal assistance dated 11 November 2014, 3 December 2014, and 28 July 2015. The Court observes that, pursuant to Article 12, Paragraph 5 of the ICSFT, the obligations under Paragraph 1 of Article 12 must be carried out in conformity with other treaties of mutual legal assistance in force between the relevant states' parties. None of the 3 aforementioned requests described in any detail the commission of alleged predicate acts by the recipients of the provided funds, nor did they indicate that the alleged funders knew that the funds provided would be used for the commission of predicate acts. Accordingly, the Court considers that the requests for legal assistance cited by Ukraine did not give rise to an obligation by the Russian Federation under Article 12 of the ICSFT to afford Ukraine the greatest measure of assistance in connection with the criminal investigations in question. For the aforementioned reasons, the Court concludes that it has not been established that the Russian Federation violated its obligations under Article 12, Paragraph 1 of the ICSFT. The Court next turns to Article 18, Paragraph 1 of the ICSFT, which requires states parties to, I quote, cooperate in the prevention of the offenses set forth in Article 2 by taking all practicable measures, inter alia, by adapting their domestic legislation if necessary to prevent and counter preparations in their respective territories for the commission of those offenses within or outside their territories. End of quote. The Court first notes that it is not necessary to find that the offense of terrorism financing has been committed for a state party to have breached its obligations under Article 18, Paragraph 1 of the ICSFT. The Court next examines the types of measures encompassed by that provision. It considers that the ordinary meaning of the term all practicable measures encompasses all reasonable and feasible measures that the state may take to prevent the commission of the offense of terrorism under Article 2 of the ICSFT. Such measures include, but are not limited to, the adoption of a regulatory framework to monitor and prevent transactions with terrorist organizations. Turning to Ukraine's submission that the Russian Federation has violated its obligations under Article 18, Paragraph 1, the applicant argues inter alia that the respondent failed to instruct its officials not to engage in terrorism financing. In this regard, Ukraine requests that the Court find the Russian Federation violated its obligations under the ICSFT not because of the actions taken by state officials in their individual capacity, but because of the Russian Federation's alleged policy of financing armed groups in eastern Ukraine. This request does not fall within the scope of Article 18 of the ICSFT and therefore cannot be upheld. Ukraine also contends that the Russian Federation breached its obligations under Article 18 by failing to investigate and prevent the financing of terrorism by private persons. The Court considers that these allegations are not covered by Article 18, but instead relate to Ukraine's claims of a violation of Articles 9, 10, and 12, which it has already addressed. The Court next finds that there is no convincing evidence demonstrating a failure by the Russian Federation to take practicable measures to prevent the movement of funds into Ukraine for the purposes of terrorism financing. Finally, the Court examines whether the Russian Federation violated its obligation under Article 18 by failing to monitor and disrupt certain fundraising networks operating in its territory, and by declining to designate the DPR or LPR as extremist or terrorist in nature. The Court recalls its findings that the Russian Federation had no reasonable grounds to suspect that the funds in question were to be used for the purpose of terrorism financing, and accordingly was under no obligation to freeze those funds. In the absence of such a reasonable suspicion, the Russian Federation was likewise not obligated under Article 18 to restrict all funding for the DPR and LPR. The Court further finds that, in the circumstances of the case, the Russian Federation was not under an obligation to designate a group as a terrorist entity under its domestic law as a preventive measure. In light of the foregoing, the Court concludes that it has not been established that the Russian Federation has violated its obligations under Article 18, Paragraph 1 of the ICSFT. Turning to the question of remedies, the Court recalls that, in respect of its claims under the ICSFT, Ukraine has requested, in addition to declaratory relief, the cessation by the Russian Federation of ongoing violations, guarantees and assurances of non-repetition, compensation, and moral damages. By the present judgment, the Court declares that the Russian Federation has violated its obligations under Article 9, Paragraph 1 of the ICSFT, and continues to be required under that provision to undertake investigations into sufficiently substantiated allegations of acts of terrorism financing in eastern Ukraine. The Court does not consider it necessary or appropriate to grant any of the other forms of relief requested by Ukraine. Having addressed Ukraine's claims under the ICSFT, the Court then turns to the applicant's claims under CERT. it first considers certain preliminary issues relevant to its decision on this aspect of the dispute. The Court notes that, as indicated earlier in this judgment, it does not consider that the clean hands doctrine is applicable in an interstate dispute where the Court's jurisdiction is established and the application is admissible. Therefore, the Court cannot uphold this defense with respect to Ukraine's claims under cert. As to the nature and scope of the alleged violations to be examined, the Court recalls that in its 2019 judgment, it rejected the preliminary objection of the Russian Federation based on the requirement of exhaustion of local remedies, and held that this requirement did not apply because, I quote, Ukraine does not adopt the cause of one or more of its nationals, but challenges, on the basis of cert, the alleged pattern of conduct by the Russian Federation with regard to the treatment of Crimean Tatar and Ukrainian communities in Ukraine. In Crimea. End of quote. At the same time, the Court noted in that judgment that, I quote, the individual instances to which Ukraine refers in its submissions emerge as illustrations of the acts by which the Russian Federation has allegedly engaged in a campaign of racial discrimination. End of quote. Accordingly, the Court is not called upon to determine in the operative paragraph of its judgment whether violation of its obligations under cert have occurred in individual instances. This does not prevent the Court from examining as illustrations any acts by which the Russian Federation has allegedly engaged in a campaign of racial discrimination. In its 2019 judgment, the Court found admissible Ukraine's claim alleging a pattern of conduct of racial discrimination by the Russian Federation. In order to arrive at the conclusion that a pattern of racial discrimination has occurred, the Court must be satisfied, firstly, that a significant number of individual acts of racial discrimination have taken place, and secondly, that these acts together constitute a pattern of racial discrimination. The Court then addresses questions of proof. It notes inter alia that in cases involving allegations of massive human rights violations, the Court has previously required convincing evidence. In the present case, the Court will therefore examine whether there is convincing evidence that individual acts of racial discrimination have taken place, and if so, whether these acts together constitute a pattern of racial discrimination. The Court then considers the meaning of the term racial discrimination in Article 1, Paragraph 1 of cert. It notes that this provision stipulates that, I quote, the term racial discrimination shall mean any distinction, exclusion, restriction, or preference based on race, color, descent, or national or ethnic origin, which has the purpose or effect of nullifying or impairing the recognition, enjoyment, or exercise on an equal footing of human rights and fundamental freedoms in the political, economic, social, cultural, or any other field of public life. End of quote. The Convention prohibits all forms and manifestations of racial discrimination as set forth by this definition. Accordingly, any differentiation of treatment that is based on one of the prohibited grounds, race, color, descent, or national or ethnic origin, is discriminatory in the sense of Article 1, Paragraph 1 of the Convention, when the resulting impairment of the recognition, enjoyment, or exercise of human rights and fundamental freedoms arises from its purpose or effect. Any measure whose purpose is a differentiation of treatment based on a prohibited ground under Article 1, Paragraph 1 constitutes an act of racial discrimination under the Convention. A measure whose stated purpose is unrelated to those prohibited grounds does not constitute in and of itself racial discrimination by virtue of the fact that it is applied to a group or to a person of a certain race, color, descent, or national or ethnic origin. However, racial discrimination may result from a measure which is neutral in its face, but whose effects show that it is based on a prohibited ground. This is the case where convincing evidence demonstrates that a measure despite being apparently neutral, produces a disparate adverse effect on the rights of a person or a group distinguished by race, color, descent, or national or ethnic origin, unless such an effect can be explained in a way that does not relate to the prohibited grounds in Article 1, Paragraph 1. Mere collateral or secondary effects on persons who are distinguished by one of the prohibited grounds do not, in and of themselves, constitute racial discrimination within the meaning of the Convention. With regard to the question of protected groups under CERD, the Court recalls that the parties agree that Crimean Tatars and ethnic Ukrainians constitute ethnic groups protected under that convention. It sees no reason to call this characterization into question. The Court observes in this context that the definition of racial discrimination in the Convention includes national or ethnic origin, and that these references to origin denote, respectively, a person's bond to a national or ethnic group at birth, as do other elements of the definition of racial discrimination, namely race, color, and descent. Accordingly, the political identity or the political position of a person or a group is not a relevant factor for the determination of their ethnic origin within the meaning of Article 1, Paragraph 1 of CERD. The Court recalls that for this aspect of the case, its jurisdiction is limited by virtue of Article 22 of CERD to Ukraine's claims under that convention. However, the fact that a court or tribunal does not have jurisdiction to rule on alleged breaches of those obligations does not mean that they do not exist. States remain responsible for acts contrary to international law which are attributable to them. The Court next turns to the specific allegations of violations of obligations under CERD, starting with the allegations concerning disappearances, murders, abductions, and torture of Crimean Tatars and ethnic Ukrainians. The Court first examines whether the acts of physical violence alleged by Ukraine constitute instances of racial discrimination within the meaning of Article 1, Paragraph 1 of CERD. Ukraine asserts that certain targeted individuals were prominent Crimean Tatar and ethnic Ukrainian activists. It also refers to reports of intergovernmental and non-governmental organizations to show that individuals affected by acts of physical violence in Crimea were disproportionately of Crimean Tatar and ethnic Ukrainian origin. The Court observes that reports by the Office of the High Commissioner for Human Rights, to which I shall refer as OHCHR, confirm that several targeted persons were pro-Ukrainian activists. The Court recalls that the political identity or political position of a person or a group is not a relevant factor for the determination of their ethnic origin. The Court therefore considers that the prominent political role and views of these persons within their respective communities do not, as such, establish that they were targeted on the basis of their ethnic origin. The Court then observes that the limited statistical evidence furnished by Ukraine is mainly derived from reports of intergovernmental organizations. While the Court generally ascribes particular weight to reports by international organizations that are specifically mandated to monitor the situation in a given area, it must also take into consideration the lack of access to Crimea of the body on whose observations the relevant reports are based. The Court is not convinced by the evidence placed before it that Crimean Tatars and ethnic Ukrainians were subjected to acts of physical violence based on their ethnic origin. In fact, any disparate adverse effect on the rights of Crimean Tatars and ethnic Ukrainians can be explained by their political opposition to the conduct of the Russian Federation in Crimea, and not by considerations relating to the prohibited grounds under CERD. With regard to Ukraine's claim that the Russian Federation did not effectively investigate the acts of physical violence involving Crimean Tatar and ethnic Ukrainian persons, the Court recalls that Article 6 establishes an obligation for states to provide effective protection and remedies through judicial and other state organs against any acts of racial discrimination. While doubts regarding the effectiveness of investigations by the Russian Federation have to be expressed in reports of intergovernmental organizations, Ukraine has not demonstrated that, at the relevant time, there existed reasonable grounds to suspect that racial discrimination had taken place, which should have prompted the Russian authorities to investigate. Consequently, Ukraine has failed to substantiate its allegation that the Russian Federation has violated its duty to investigate under Article 6 of CERD. The Court concludes that it has not been established that the Russian Federation has violated its obligations under CERD on account of incidents of physical violence alleged by Ukraine. The Court then addresses the allegations concerning the respondents' conduct in terms of law enforcement measures, including searches, detentions, and prosecutions. It begins by considering the question whether the legislation adopted by the Russian Federation in itself constitutes racial discrimination. The Court notes that the conformity of the relevant laws of the Russian Federation, in particular the provision on extremist activities, with the human rights obligations of the state, has been called into question by international judicial and monitoring bodies on the basis that they are very broadly worded, thereby allowing wide discretion in their interpretation and application, thus leading to arbitrariness and potential dangers to individuals and NGOs. The Court observes that no evidence has been put before the Court which would suggest that the purpose of the relevant domestic law is to differentiate between persons based on one of the prohibited grounds contained in Article 1, Paragraph 1 of CERD, nor that this legal framework is likely to produce a disparate adverse effect on the rights of Crimean Tatars or ethnic Ukrainians. Therefore, the Court is of the view that the domestic legal framework in and of itself does not constitute a violation of CERD. However, this finding is without prejudice to the question whether the application of such domestic legislation is in breach of obligations under CERD. The Court notes that both parties distinguish between the application of these domestic laws in the wider Crimean Tatar population on the one hand, and to persons forming part of the Crimean Tatar leadership on the other. It therefore addresses these two categories separately and in turn. In the present case, Ukraine has provided evidence suggesting that persons of Crimean Tatar origin have been particularly exposed to law enforcement measures taken by the Russian Federation. The Court must therefore examine whether these measures had either the purpose of targeting Crimean Tatars or a disparate adverse effect on the rights of members of this group. In light of the reports of several UN organs and monitoring bodies, the Court finds that Ukraine has sufficiently demonstrated that the law enforcement measures concerned produced a disparate adverse effect on the rights of persons of Crimean Tatar origin. It then proceeds to consider whether such effect can be explained in a way that does not relate to the prohibited grounds in Article 1, Paragraph 1 of CERD. The Court notes that the stated purpose of certain measures appears to have served as a pretext for targeting persons who, because of their religious or political affiliation, the Russian Federation deems to be a threat to its national security. However, the Court is of the view that Ukraine has not presented convincing evidence to establish that persons of Crimean Tatar origin were subjected to such law enforcement measures based on their ethnic origin. With respect to Ukraine's claim that the Russian Federation violated Article 4 of CERD concerning the promotion and incitement of racial discrimination, Ukraine has not presented convincing evidence that statements have been made by state officials of the Russian Federation that were directed against Crimean Tatars based on their ethnic or national origin. Nor does Ukraine prove its allegation that the Russian Federation failed to comply with its obligation to prevent, eradicate, and punish speech by private persons seeking to promote or justify racial hatred against Crimean Tatar and ethnic Ukrainians based on their national or ethnic origin. Turning to Ukraine's claims that the Russian Federation violated Article 6 by failing to investigate effectively allegations of discriminatory law enforcement measures, The Court considers that Ukraine failed to demonstrate that there were, at the relevant time, reasonable grounds to suspect that racial discrimination had taken place, which should have prompted the Russian Federations to investigate. For these reasons, the Court is not convinced that the Russian Federation has engaged in law enforcement measures that discriminate against persons of Crimean Tatar origin based on their ethnic origin. Turning to the application of Russian domestic laws to persons forming part of the Crimean Tatar leadership, the Court notes that the Russian Federation does not contest the occurrence of the alleged measures taken against the Mejlis prior to its ban and against Crimean Tatar leaders, but disputes that they constitute acts of racial discrimination under cert. The Court recalls that the fact that targeted persons belong to the leadership of an ethnic group does not in and of itself suffice to establish that measures which adversely affect such persons amount to racial discrimination. Ukraine would also need to demonstrate that the relevant measures were based on the ethnic origin of the persons or the ethnically representative character of the institutions subjected to these measures. The Court considers that the context in which the measures were taken indicates that they were in response to the political opposition that these persons and institutions displayed against the exercise of territorial control by the Russian Federation in Crimea. In the Court's view, Ukraine has not substantiated the claim that Crimean Tatar leaders who had engaged in political opposition against the control of Crimea by the Russian Federation were disproportionately affected by law enforcement measures compared with other persons who were engaged in similar conduct. The Court thus considers that the measures concerned were not based on the ethnic origin of the targeted persons. Taking all these considerations into account, the Court concludes that it has not been established that the measures taken by the Russian Federation against the members of the Mejlis were based on the ethnic origin of the persons concerned. The Court next addresses the parties' arguments regarding the ban on the Mejlis. It notes at the outset that various intergovernmental organizations and monitoring bodies have called upon the Russian Federation to lift that ban because of its negative impact on civil and political rights. However, the Court's jurisdiction in the present case is confined to assessing the conformity of that ban with the Russian Federation's obligations under cert. The Court first examines the question whether the ban on the Mejlis constitutes an act of racial discrimination within the meaning of Article 1, Paragraph 1 of cert. The ban entails the exclusion of the Mejlis from public life in Crimea. However, for the ban to amount to racial discrimination, Ukraine would also need to demonstrate that this exclusion was based on the ethnic origin of Crimean Tatars as a group, or of the members of the Mejlis, and that it had the purpose or effect of nullifying or impairing the enjoyment of their rights. The Court acknowledges that the Mejlis has historically played an important role in representing the interests of the Crimean Tatar community since the community resettled in Crimea in 1991, after being deported to Central Asia in 1944. At the same time, the Court is of the view that the Mejlis is neither the only nor the primary institution representing the Crimean Tatar community. The Court is not convinced that Ukraine has substantiated its claim that the ban on the Mejlis deprived the wider Crimean Tatar population of its representation. It follows that it is not necessary in this case for the Court to determine under which circumstances the treatment of institutions representing groups that are distinguished by their national or ethnic origin may violate obligations under cert. The ban on the Mejlis by its very nature also produces a disparate, adverse effect on the rights of persons of Crimean Tatar origin, insofar as the members of the Mejlis are, without exception, of Crimean Tatar origin. However, the Court needs to assess whether this effect can be explained in a way that does not relate to the prohibited grounds in Article 1, Paragraph 1. Based on the evidence before it, it appears to the Court that the Mejlis was banned due to the political activities carried out by some of its leaders in opposition to the Russian Federation, rather than on grounds of their ethnic origin. The court thus concludes that Ukraine has not provided convincing evidence that the ban of the Mejlis constitutes an act of discrimination within the meaning of Article 1, Paragraph 1 of CERD. With respect to Ukraine's claim that the Russian Federation violated Article 4 of CERD, the court is not satisfied that, by adopting the ban of the Mejlis, authorities or institutions of the Russian Federation promoted or incited racial discrimination. Turning to Ukraine's claim that the Russian Federation violated its obligations under Article 6 of CERD, the court observes that Ukraine did not establish that effective redress was denied by the Russian Federation. For these reasons, the court concludes that it has not been established that the Russian Federation violated its obligations under CERD by imposing a ban on the Mejlis. The court then turns to the claims concerning measures relating to citizenship, particularly whether the citizenship regime introduced by the Russian Federation in Crimea and the measures based thereon fall within the scope of Article 1 of CERD. The court notes that differential treatment between citizens and non-citizens and domestic legal provisions concerning nationality, citizenship, or naturalization are per se excluded from the scope of the Convention. CERD is thus not concerned with the grounds on which or the way in which nationality is granted. However, this cannot be understood as excluding from the scope of CERD any application of citizenship laws that results in an act of discrimination based on national or ethnic origin by purpose or effect. In the present case, the court does not find that Ukraine has convincingly established that the application of the Russian citizenship regime in Crimea amounts to a differentiation of treatment based on ethnic origin. It concludes that it has not been established that the Russian Federation has violated its obligations under CERD through the adoption and application of its citizenship regime in Crimea. With regard to measures relating to culturally significant gatherings, the court observes that the conformity of the relevant laws of the Russian Federation, notably the provisions on extremism, with that state's human rights obligations, has been called into question by international judicial and expert bodies, owing to the risk of arbitrary interpretation and abuse. The court concludes, however, that there is no evidence that would suggest that the purpose of the relevant domestic legislation is to differentiate based on one of the prohibited grounds contained in Article 1, Paragraph 1 of CERD, or that this legal framework is likely to produce a disparate adverse effect on the rights of persons of Crimean Tatar or ethnic Ukrainian origin. Therefore, the court is of the view that the domestic legal framework does not in and of itself constitute a violation of the obligation under CERD. The court observes that reports by intergovernmental and non-governmental organizations suggest that prohibitions and other restrictions imposed on gatherings commemorating certain events produced a disparate adverse effect on the rights of Crimean Tatars. However, the Russian Federation has provided explanations for these restrictions that do not relate to one of the prohibited grounds contained in Article 1, Paragraph 1 of the Convention. There is evidence that certain ethnic Ukrainian and Crimean Tatar organizations have in fact been successful in applying to hold events, and that multiple events organized by ethnic Russians have been denied. Moreover, given the context of these restrictions, Ukraine has not, in the court's view, sufficiently substantiated its assertion that the restrictions were based on one or more of the prohibited grounds. For these reasons, the court concludes that it has not been established that the Russian Federation has violated its obligations under CERD by imposing restrictions on gatherings of cultural importance to the Crimean Tatar and ethnic Ukrainian communities. With regard to measures concerning media outlets, the court recalls that restrictions imposed on media organizations fall within the scope of CERD only insofar as these media organizations are collective bodies or associations which represent individuals or groups of individuals, and the measures imposed on them are based on national or ethnic origin. The relevant domestic legal framework regulates the activities of mass media and the prevention, prosecution, and punishment of certain broadly defined criminal offenses. The Court considers that this legal framework does not, in and of itself, constitute a violation of the Russian Federation's obligations under CERD. Moreover, on the evidence submitted by Ukraine, the Court cannot find that the measures taken against Crimean Tatar and Ukrainian media outlets were based on the ethnic origin of the persons affiliated with them. The Court is of the view that the explanations given by the Russian Federation, particularly the statistically substantiated comparison between the closure of media outlets in Crimea and other territories, suggests that the restrictions were not based on national or ethnic origin. For these reasons, the Court concludes that it has not been established that the Russian Federation violated its obligations under CERD by imposing restrictions on Crimean Tatar and Ukrainian media and by taking measures against persons affiliated with Crimean Tatar and Ukrainian media organizations. The Court then turns to the claims concerning measures relating to cultural heritage and cultural institutions. The Court finds that Ukraine has not sufficiently substantiated its claims regarding the alleged degradation of Crimean Tatar cultural sites and its contention that the measures undertaken by the Russian Federation regarding the sites in question discriminate against the Crimean Tatars as a group. With respect to Ukraine's allegations concerning the degradation of certain aspects of cultural heritage of ethnic Ukrainians, the Court is of the view that Ukraine has not established that any differentiation of treatment of persons affiliated with cultural institutions in Crimea was based on their ethnic origin. The Court notes that the Russian Federation has provided explanations for the measures taken against the persons in question that are unrelated to the prohibited grounds. The Court also notes that the Russian Federation has provided evidence substantiating its attempts at preserving Ukrainian cultural heritage and has provided explanations for the measures undertaken with respect to that heritage. Ukraine, in turn, has not substantiated how the closure of certain institutions would amount to discrimination based on ethnic origin. For these reasons, the Court concludes that it has not been established that the Russian Federation has violated its obligations under CERD by taking measures relating to the cultural heritage of the Crimean Tatar and ethnic Ukrainian communities. The Court then examines whether the conduct of the Russian Federation with regard to education in Crimea qualifies as racial discrimination and violates the obligations contained in Articles 2.1a, 5e, 5, and 7. Under Article 2.1a, each state party undertakes not to engage in any act or practice of racial discrimination against persons, groups of persons, or institutions, and to ensure that all public authorities and public institutions, national and local, act in conformity with this obligation. Under Article 5E5, states parties undertake to prohibit and eliminate racial discrimination and to guarantee the right of everyone, without distinction as to race, color, or national or ethnic origin, to equality before the law, notably in the enjoyment of certain categories of rights, including the right to education and training. The Court considers that even if Article 5E5 of CERD does not include a general right to school education in a minority language, the prohibition of racial discrimination under Article 2.1a of CERD and the right to education under Article 5E5 may, under certain circumstances, set limits to the changes in the provision of school education in the language of a national or ethnic minority. For those provisions to apply, the Court must first determine whether the conduct in question qualifies as racial discrimination within the meaning of Article 1, Paragraph 1 of CERD. Most of the measures complained of by Ukraine concern limitations to the availability of Ukrainian or Crimean Tatar as the language of instruction in primary schools. Language is often an essential social bond among members of an ethnic group. Restrictive measures taken by a state party with respect to the use of language may therefore, in certain circumstances, manifest a distinction, exclusion, restriction, or preference based on descent or national or ethnic origin within the meaning of Article 1, Paragraph 1 of CERD. States parties possess broad discretion under CERD with respect to school curricula and with respect to the primary language of instruction. However, in designing and implementing a school curriculum, a state party may not discriminate against a national or ethnic group. The fact that a state chooses to offer school education in only one language does not in and of itself give rise to discrimination under CERD against members of a national or ethnic minority who wish to have children educated in their own language. Structural changes with respect to the available language of instruction in schools may constitute discrimination prohibited under CERD if the way in which they are implemented produces a disparate adverse effect on the rights of a person or group distinguished by one of the grounds listed in Article 1, Paragraph 1 of CERD, unless such an effect can be explained in a way that does not relate to those prohibited grounds. This would be the case in particular if a change in the education in the minority language available in public schools is implemented in such a way, including by means of informal pressure, as to make it unreasonably difficult for members of a national or ethnic group to ensure that their children, as part of their general right to education, do not suffer from unduly burdensome discontinuities in their primary language of instruction. With respect to school education in the Ukrainian language, the Court notes that there was a steep decline in the number of students receiving their school education in the Ukrainian language between 2014 and 2016. According to data from the OHCHR, there was an 80% decline in the number of students receiving an education in the Ukrainian language during the first year after 2014, and a further decline of 50% by the following year. It is undisputed that no such decline has taken place with respect to school education in other languages. Such a sudden and steep decline produced a disparate adverse effect on the rights of ethnic Ukrainian children and their parents. The Russian Federation exercises full control over the public school system in Crimea, in particular over the language of instruction and the conditions for its use by parents and children. The explanations put forward by the Russian Federation for the decline in the number of students receiving school education in the Ukrainian language are not fully convincing. It is true that, according to the OHCHR, the main reason for this decrease include a dominant Russian cultural environment and the departure of thousands of pro-Ukrainian Crimean residents to mainland Ukraine. However, even considering that many ethnic Ukrainian families left Crimea in 2014, the Court is not convinced that this, together with the reorientation of the Crimean school system towards Russia, can alone account for a reduction of more than 90% of genuine demand in Crimea for school instruction in the Ukrainian language. Although the Court is unable to conclude on the basis of the evidence presented that parents have been subjected to harassment or manipulative conduct aimed at deterring them from articulating their preference, the Court is of the view that the Russian Federation has not demonstrated that it complied with its duty to protect the rights of ethnic Ukrainians from a disparate adverse effect based on their ethnic origin by taking measures to mitigate the pressure resulting from the reorientation of the Crimean educational system on parents whose children had until 2014 received their school education in the Ukrainian language. With respect to school education in the Crimean Tatar language, the Court notes that Ukraine's claims concern the quality of the education available in that language rather than its actual availability or a significant change in the number of students. The Court is unable to conclude, based on the evidence submitted to it by the parties, that the quality of the education in the Crimean Tatar language has significantly deteriorated since 2014. Regarding the alleged violation of the obligation under Article 7 of CERD, the evidence before the Court does not demonstrate that the Russian Federation failed to adopt immediate and effective measures against racial discrimination. The Court then notes that to assess whether the Russian Federation violated its obligations under CERD in the present case, it needs to determine if the violations found constitute a pattern of racial discrimination. The legislative and other practices of the Russian Federation with regard to school education in the Ukrainian language and Crimea apply to all children of Ukrainian ethnic origin whose parents wished them to be instructed in the Ukrainian language and thus did not merely include individual cases. As such, it appears that this practice was intended to lead to a structural change in the educational system. The Court is therefore of the view that the conduct in question constitutes a pattern of racial discrimination. In light of these considerations, the Court concludes that the Russian Federation has violated its obligations under Article 21A and Article 5E5 of CERD by the way in which it has implemented its educational system in Crimea after 2014 with regard to school education in the Ukrainian language. The Court then turns to the question of remedies. In respect of claims under CERD, Ukraine has requested, in addition to a declaration of violations, the cessation by the Russian Federation of ongoing violations, guarantees and assurances of non-repetition, compensation, and moral damages. By the present judgment, the Court declares that the Russian Federation has violated its obligations under Article 21A of CERD and Article 5E5 of CERD. It considers that the Russian Federation remains under an obligation to ensure that the system of instruction in the Ukrainian language gives due regard to the needs and reasonable expectations of children and parents of Ukrainian ethnic origin. The Court does not find it necessary or appropriate to order any other remedy requested by Ukraine. Having addressed Ukraine's claims under the ICSFT and CERD, the Court turns to the request made by the applicant in its final submissions that the Court adjudge and declare that the Russian Federation has breached its obligations under the Court's order of 19 April 2017, indicating provisional measures. There the Court ordered that, I quote, 1. With regard to the situation in Crimea, the Russian Federation must, in accordance with its obligations under the International Convention on the Elimination of All Forms of Racial Discrimination, a. refrain from maintaining or imposing limitations on the ability of the Crimean Tatar community to conserve its representative institutions, including the Mejlis." End of quote. It is uncontested between the parties that the Russian Federation has neither suspended nor lifted the ban on the Mejlis. However, the parties disagree about whether the chapeau of the provisional measure, by its reference to CERD, can be interpreted as leaving a margin of discretion for the Russian Federation as to how to implement its obligations under the measure. The Court recalls that obligations arising from provisional measures bind the parties independently of the factual or legal situation which the provisional measures in question aims to preserve. The Court is of the view that the reference in the order of 19 April 2017 to the obligations of the Russian Federation under CERD does not provide any scope for the Russian Federation to assess for itself whether the ban on the Mejlis and the confirmation of the ban by the Russian courts were and remain justified. The formulation in the chapeau refers to the source of the rights which the measure seeks to preserve and does not qualify the measure or confer discretion upon the party addressed to decide whether or not to implement the measure indicated. The Court therefore finds that the Russian Federation, by maintaining the ban on the Mejlis, has violated the order on provisional measures. The Court notes that this finding is independent of its conclusion reached earlier that the ban on the Mejlis does not violate the Russian Federation's obligations under CERD. With respect to the second provisional measure, the Court notes that the order of 19 April 2017 required the Russian Federation to ensure that education in the Ukrainian language remains available. In this regard, the Court takes note of a report by OHCHR, which confirms that instruction in the Ukrainian language was available after the adoption of the order. While Ukraine has shown that a sharp decline in teaching in the Ukrainian language took place after 2014, it has not been established that the Russian Federation has violated the obligation to ensure the availability of education in Ukrainian language contained in the Order on Provisional Measures. In the Order on Provisional Measures, the Court also stated that, I quote, "Both parties shall refrain from any action which might aggravate or extend the dispute before the Court or make it more difficult to resolve." End of quote. The Court observes that, subsequent to the Order on Provisional Measures, the Russian Federation recognized the DPR and the LPR as independent states and launched what it called a special military operation against Ukraine. In the view of the Court, these actions severely undermined the basis for mutual trust and cooperation and thus made the dispute more difficult to resolve. For these reasons, the Court concludes that the Russian Federation violated the obligation under the order to refrain from any action which might aggravate or extend the dispute before the Court or make it more difficult to resolve. The Court recalls that orders indicating provisional measures create a legal obligation for the states involved. The Court considers that its declaration that the Russian Federation has breached the Order on Provisional Measures of 19 April 2017 by maintaining the ban on the Mejlis and has breached its obligations under the non-aggravation measure contained in the same order provides adequate satisfaction to Ukraine. Regarding Ukraine's request for restitution with respect to the Mejlis, the Court finds that, since it has concluded that the ban on the Mejlis did not violate the Russian Federation's obligations under CERD, no restitution can be due after the date of this finding, the assessment at the provisional measure stage having not been confirmed at the merits. The Court does not find it necessary or appropriate to order any other remedy requested by Ukraine. I shall now read the operative part of the judgment. For these reasons, the Court, by 13 votes to 3, finds that the Russian Federation, by failing to take measures to investigate facts contained in information received from Ukraine regarding persons who have allegedly committed an offense set forth in Article 2 of the International Convention for the Suppression of the Financing of Terrorism, has violated its obligation under Article 9, Paragraph 1 of the said convention. In favor, President Donahue, Judges Tomka, Abraham, Benuna, Yusuf, Sabatinde, Bandari, Salam, Iwasawa, Nolte, Charlesworth, Brandt, Judge Ad hoc Pokar. Against, Judge Shui, Judge Ad hoc Tuzmukhamedov. 2. By 10 votes to 5, rejects all other submissions made by Ukraine with respect to the International Convention for the Suppression of the Financing of Terrorism. In favor, Judges Tomka, Abraham, Benuna, Yusuf, Shui, Salam, Iwasawa, Nolte, Brandt, Judge Ad hoc Tuzmukhamedov. Against, President Donahue, Judges Sabatinde, Bandari, Charlesworth, Judge Ad hoc Pokar. 3. By 13 votes to 2, finds that the Russian Federation, by the way in which it has implemented its educational systems in Crimea after 2014 with regard to school education in the Ukrainian language, has violated its obligations under Article 2, Paragraph 1a, and 5E5 of the International Convention on the Elimination of Racial Discrimination. In favor, President Donahue, Judges Tomka, Abraham, Benuna, Shui, Sabatinde, Bandari, Salam, Iwasawa, Nolte, Charlesworth, Brandt, Judge Ad hoc Pokar. Against, Judge Yusuf, Judge Ad hoc Tuzmukhamedov. 4. by 10 votes to 5, rejects all other submissions made by Ukraine with respect to the International Convention on the Elimination of Racial Discrimination. In favor, Judges Tomka, Abraham, Benuna, Yusuf, Shway, Salam, Iwasawa, Nolte, Brandt, Judge Ad hoc Tuzmuhamedov. Against, President Donahue, Judges Sebatinde, Bandari, Charlesworth, Judge Ad hoc Pokar. By 11 votes to 4, finds that the Russian Federation, by maintaining limitations on the Mejlis, has violated its obligation under paragraph 106(1)(a) of the order of 19 April 2017, indicating provisional measures. In favor, President Donahue, Judges Abraham, Benuna, Yusuf, Sebatinde, Bandari, Salam, Iwasawa, Nolte, Charlesworth, Judge Ad hoc Pokar. Against, Judges Tomka, Shway, Brandt, Judge Ad hoc Tuzmuhamedov. 6. By 10 votes to 5, finds that the Russian Federation has violated its obligation under paragraph 106(2) of the order of 19 April 2017, indicating provisional measures to refrain from any action which might aggravate or extend the dispute between the parties or make it more difficult to resolve. In favor, President Donahue, Judges Tomka, Sebatinde, Bandari, Salam, Iwasawa, Nolte, Charlesworth, Brandt, Judge Ad hoc Pokar. Against, Judges Abraham, Benuna, Yusuf, Shway, Judge Ad hoc Tuzmuhamedov. 7. By 11 votes to 4, rejects all other submissions made by Ukraine with respect to the order of the Court of 19 April 17, indicating provisional measures. In favor, President Donahue, Judges Tomka, Abraham, Benuna, Yusuf, Shway, Bandari, Salam, Iwasawa, Brandt, Judge Ad hoc Tuzmuhamedov. Against, Judges Sebatinde, Nolte, Charlesworth, Judge Ad hoc Pokar. I shall now call upon the Registrar to read the operative part of the judgment in French.
Par ces motifs, la Cour, 1 par 13 voix contre 2, dit que la Fédération de Russie, en s'abstenant de prendre des mesures pour enquêter sur les faits portés à sa connaissance par l'Ukraine, concernant les auteurs présumés d'une infraction visée à l'article 2 de la Convention internationale pour la répression du financement du terrorisme, a manqué à l'obligation que lui impose le paragraphe 1 de l'article 9 de la dite Convention. Pour Madame Donoyou, présidente, Messieurs Tomka, Abraham, Benuna, Youssouf, Madame Sebutinde, Messieurs Bandari, Salam, Iwasawa, Nolte, Madame Charlesworth, Monsieur Brand, juge, Monsieur Pokar, juge ad hoc. Contre, Madame Chouet, juge, Monsieur Tuzmuhamedov, juge ad hoc. 2. Par 10 voix contre 5. Rejette le surplus des conclusions présentées par l'Ukraine en ce qui a trait à la Convention internationale pour la répression du financement du terrorisme. Pour Messieurs Tomka, Abraham, Benuna, Youssouf, Madame Chouet, Messieurs Salam, Iwasawa, Nolte, Brandt, juge, Monsieur Tuzmuhamedov, juge ad hoc. Contre, Madame Donoyou, présidente, Madame Sebutinde, Monsieur Bandari, Madame Charlesworth, juge, Monsieur Pokar, juge ad hoc. 3. Par 13 voix contre 2, dit que la Fédération de Russie, par la manière dont elle a mis en place son système d'éducation en Crimée après 2014, pour ce qui est de l'enseignement scolaire en langue ukrainienne, a manqué aux obligations que lui impose l'alinéa A du paragraphe 1 de l'article 2 et le point 5 de l'alinéa E de l'article 5 de la Convention internationale sur l'élimination de toutes les formes de discrimination raciale. Pour Madame Donoyou, présidente, Messieurs Tomka, Abraham, Benuna, Mesdames Chouet, Sebutinde, Messieurs Bandari, Salam, Iwasawa, Nolte, Madame Charlesworth, Monsieur Brand, juge, Monsieur Pokar, juge ad hoc. Contre, Monsieur Youssouf, juge, Monsieur Tuzmuhamedov, juge ad hoc. 4. Par 10 voix contre 5, rejette le surplus des conclusions présentées par l'Ukraine en ce qui a trait à la Convention internationale sur l'élimination de toutes les formes de discrimination raciale. Pour Messieurs Tomka, Abraham, Benouna, Youssouf, Madame Choué, Messieurs Salam, Iwasawa, Nolt, Brandt, juge, Monsieur Touzmoukhamedov, juge ad hoc, contre, Madame Donoyou, présidente, Mesdames Seboutinde, Monsieur Bandari, Madame Charlesworth, juge, Monsieur Pocard, juge ad hoc. 5. Par 11 voix contre 4, dit que la Fédération de Russie, en maintenant l'imposition de limitation au Majlis, a manqué à l'obligation que lui imposait le point 1A du dispositif, paragraphe 106, de l'ordonnance en indication de mesures conservatoires du 19 avril 2017. Pour Madame Donoyou, présidente, Messieurs Abraham, Benouna, Youssouf, Madame Seboutinde, Messieurs Bandari, Salam, Iwasawa, Nolt, Madame Charlesworth, juge, Monsieur Pocard, juge ad hoc. Contre, Monsieur Tomka, Madame Choué, Monsieur Brandt, juge, Monsieur Touzmoukhamedov, juge ad hoc. 6. Par 10 voix contre 5,